All right. So I'm David Grant. I'm an assistant professor in the philosophy department here at UF. The topic of this panel is algorithmic justice. And the goal of this workshop today overall is to introduce you to research and teaching at UF that engages with AI in a variety of ways. In this panel, we're going to hear some short talks from myself and my co-panelists, Barbara Evans and Hina Shaikh, about our work in AI ethics, and more specifically our work on questions about justice that are raised by contemporary applications of AI. Okay, so time's short. I want to leave plenty of room for Q&A, so I'm just going to briefly introduce my co-panelists, and then we're going to launch right into the talks. Okay, so Barbara Evans, on the far end here, is a professor of law and Stephen C. O'Connell Chair at the UF Levin College of Law, and holds a joint appointment as Professor of Engineering and Rumwick Faculty Fellow in AI and Ethics at the Herbert Wertheim College of Engineering at UF. She works with data privacy, civil rights, and FDA regulatory issues affecting advanced biomedical technologies, including AI/ML, clinical decision support software, and she is currently legal study lead and co-chair of the ethics working group for the NIH-funded Bridge to A Chorus project, in which UF is participating. And then Hina Shaikh is an assistant professor of gender, sexuality, and women's studies. She also leads the Data Justice Lab, and her forthcoming book project, congratulations, is entitled Fractured Patterns, Data, Space, and the Search for Muslim Women. Okay, so we're going to go in alphabetical order. With no further ado, Barbara Evans is going to tell us about her work on data privacy and algorithmic justice.
Thank you for having me here today. Is the sound level okay? Good. I don't have any relevant conflicts to disclose. And what I'd like to talk about is there's a tendency to AI exceptionalism now, where law scholars and scholars across academic disciplines are acting as though something really novel has happened, like an asteroid striking, and we all need to develop special frameworks for it. And I have mixed feelings about that. In some instances, the modeling isn't really all that different from things we were doing some years ago. It's just better and more of it. In other ways, though, AI kind of forces us to question everything that we thought was correct about the ethical and justice dimensions. There have been many, many efforts. This is one of them, the White House Blueprint for an AI Bill of Rights that came out almost exactly a year ago. And it tried to set general principles that would govern all AI in all implementations in every sector. And it identified these principles. We want the systems to be safe and effective. We want protections against algorithmic discrimination. We want data privacy. And people should know when AI is being used to order their affairs, and understand the impacts, and access to human alternatives when possible, that if I don't like the loan denial the AI gives me, I should have recourse to a human banker that I can make my case to. Now, these are all great principles. Notice how with data privacy, the blueprint defined it that we should have a consent right, that we should always be able to consent whether our data are being used or not, and ethics review for certain types of data, such as health data. These are old 1970s era ethics ideas that grew up in the late 1970s about the right of people to consent to use their data. The blueprint noted that sometimes you may need exceptions to the principles, that there may be competing interests that need to be balanced, and that is so true in the matter of privacy and AI. There are trade-offs between privacy and transparency. If we want to make our systems really transparent and put a lot of information out there about how they work, hackers can use that to to sort of attack the systems and extract data from them. There are trade-offs between how safe these systems will be and privacy. The more data you can get into them, the more inclusive the data sets, the better they will perform for more people. And there are some very disturbing trade-offs between privacy, if you define it as a consent right, and equity and anti-bias and anti-discrimination. In the medical field where I work, there are growing numbers of studies that show there are real gender and racial and cultural and socioeconomic differences in whether people like to consent to have their data used in research and other numerical applications or not. So if we say that privacy requires a consent right, that itself creates a bias in which there's a greater tendency of white males to consent than other people consent. And just by having that as our notion of what privacy requires can create a set of rules that, while they seem neutral on their face, have a disparate impact that may cause some populations to be underrepresented in the data sets used to train these AIs. So what my work has been doing is asking whether our existing concepts of privacy law are part of the system that may be leading to some systemic injustice. This concept of systemic injustice gets at the notion that there are certain things that are just baked into the way society works that can feed disparate outcomes, health inequities. And so I've been looking at whether our 1970s era concepts about privacy could be having an unintended consequence that is making medical AI systems work less well for women, transgender patients, people of color, and people who are not economically privileged. And there's growing evidence that that's how our systems are doing that we have right now. Another thing is people love grand statements of principles like the Biden White House blueprint is going to answer our questions about all AI in all applications in every context, and that's nice, but the fact is, with AI, it makes a lot of difference to the ethical analysis, what domain you're in. Are you working with medical AI, financial AI, law enforcement AI, online privacy? You need different rules because the balances of benefits and risks are different in those different environments. You're using different types of data with different attack risks, and there are different benefits. And to weigh those and balance the interests, you need to get very, very granular about what is the intended application of an AI system. One of the problems we have is that if we say consent is not the key way we're going to protect privacy, we have to figure out, well, what else can we do? And how will we protect it? And this is an area where there's a lot of interesting principles already in law that people sometimes aren't aware of. Decisional privacy is where we allow each person to make their own individual decisions and decide what they want to do, and you don't impose legal rules that force them to do one thing or the other. At the other extreme is strict public ordering, where we let Congress set the rules. We let public entities of government set the rules. Courts tell you when your data can be used. The legislature passes a public health law that says your data have to go into a disease tracking system. Between those two extremes, when you get into specific legal contexts, there's a lot of mid-range alternatives, private ordering, it's called, where law engages private actors to help set up rules and implement them. For example, our research regulations appoint institutional review boards, which are private sector bodies within institutions like University of Florida to help oversee certain decisions. They are a private body, but they're authorized to act under governmental regulations. Other times we let private actors completely make rules on their own. For example, the Code of Medical Ethics requires a lot of privacy, and that code is developed by physicians at the American Medical Association. The regulated entities are announcing their own rules. Now, the problem is when you go to these middle extremes between full decisional privacy and just government set rules, it's very hard to set up decision-making structures that will inspire trust and seem incorruptible and just. And that's one of the challenges we face. In our AI-enabled economy, it's hard for legislatures to pass one rule that will deal with every nuance. There's going to need to be granular, day-to-day routine decisions about data use that require some delegation to make day-to-day decisions. And how can we create institutions for decision-making about when can data be used in an AI system that will strike people as reliable and trustworthy? Now, there's two competing visions of data privacy that coexist in our legal frameworks, and this is true not just in the US, but you see it in Europe under GDPR, their regulation. One popular view now is control over information theory, where you focus on the individual's right to control their data and to say who can have it, who can use it. This has been favored by bioethicists and information privacy law scholars since the 1970s. It conceives privacy as this right to consent or even a right to own your data. And it conceives persons very individually as rugged individuals who will protect themselves and control their own fate. The problem with this model is it stresses autonomy and the rights of the individual over competing moral values such as beneficence, justice, equity. If you let people make fully autonomous individual decisions, that doesn't always lead to societally good outcomes. The contrasting method, which doesn't just date back to the 70s, it dates back to Hippocrates 2,400 years ago, is that people as individuals really can't protect their privacy. It depends on the relationships they have. If you go to a party and someone else there takes a selfie that has you drunk in the background and puts it on social media, that's going to invade your privacy and disclose things about you you may not have wished to share with your employer, for example. Privacy is interdependent. And ultimately, we can't protect our own privacy just by controlling who gets access to our data. This older approach says that certain people who are in positions to handle data should be under some really binding duties of confidentiality not to misuse it. The consent-based system we have basically says someone else, a corporation, a researcher, somebody will decide how they use the data, and then you can say yes, no to that use. This other approach says no, rather than have you consent to have your data misused, let's put some really meaningful constraints on the people who handle the data, a confidentiality-based system. These are widely used in the healthcare field, they're widely used in the professions, accountants, lawyers, and they exist in all systems, and they don't rely so heavily on this notion of you consent as they do on let's put some meaningful rules on what can be done with data. Now, just as an example, this is a very popular unpopular medical privacy regulation, the HIPAA privacy rule, which applies to data held in hospitals, clinics, insurers. It does provide that data can be released with consent, which I've shown they call consent authorization. But as you go on down, it has all of these ways that it's okay to release your data without your consent. And that's very disturbing to people until you realize that a lot of these releases are to very reliable entities such as courts. They're unlikely to misuse your data, to governmental entities that are under strict privacy regulations to keep it confidential, to doctors who can lose their license if they leak your data. But even so, people are concerned about this, and yet these uses serve socially beneficial purposes. They let us track epidemics, detect child abuse, promote civil rights in healthcare so that we can detect it if people are suffering from inequitable care. You need flows of data to provide broad social benefits. The question is, can we constrain the recipients enough to make it safe? So my last slide is that I think to make AI uses of data seem ethical and trustworthy to those of us whose data are used in these systems, we need to face reality that the old way of just de-identifying data is so easy to work around now to re-identify, and that consent norms, while they are polite, they don't really provide good privacy protection, because our privacy is so interdependent now that it's not just what we do, but what others do that affects our collective privacy. And consent rights can have some really disturbing tendencies to promote bias, because there are disparate impacts about whether people consent or not. And they can leave out certain groups and create systemic biases in the data sets. So perhaps the way to protect privacy is to get really serious now about strengthening the fiduciary obligations, the duties of data handlers to limit what they do with data, and also have some sort of oversight so that we stop using data for frivolous things. And if we're going to put people's privacy at risk by accessing their data, perhaps we need to figure out which uses are really worth the risk that it entails. Well, with that, I will cease and desist and hand this off. Who is our next speaker? Are we alphabetical? To David Grant.
Seemingly fair algorithm. Thank you, Barbara. All right. Thank you very much. I'm just going to load up my... The thing with PowerPoint is that the presentations are in different slide templates. Okay. Great. All right. So as you all know, and as Barbara's been discussing, predictive algorithms are increasingly used to make high-stakes decisions about how to treat particular individuals. So experts initially thought that decision-making algorithms would be free of the biases that affect human decision makers, more or less by default, and that using them would therefore sort of make it so that we were sort of treating people more fairly than we were when humans were making the decisions. So of course we now know that that's not true, since algorithms are designed by humans, and since they're built using data from human societies, they tend to inherit many of our biases. Okay, so as many of you know, computer scientists and statisticians have responded to concerns about algorithmic bias by proposing that we quantify the degree to which algorithms treat people fairly using so-called statistical criteria of fairness. So these are statistical measures of an algorithm's performance. They measure how often the algorithm makes particular kinds of mistakes, as well as how those mistakes tend to be distributed across different groups. But they're also supposed to be ways of measuring different dimensions of fairness in prediction. So poor performance in a particular criterion is supposed to demonstrate that the algorithm treats members of a particular group unfairly. Okay, so the trouble is that numerous of these criteria have been proposed, and it's typically not possible to satisfy all of them at once. And moreover, satisfying them often comes at a very steep cost in terms of overall accuracy and effectiveness, which often matters a great deal. So for example, if we're trying to determine whether patients have a highly infectious disease, then sacrificing overall accuracy in order to sort of balance error rates across groups might end up sort of leaving everybody worse off. Okay, so this makes it crucial for us to try to determine whether statistical criteria of fairness are really doing what they're supposed to do, which is measuring the extent to which different groups are being treated fairly. And that turns out to be a surprisingly difficult problem. So the various criteria that have been proposed tend not to map onto our pre-existing theories about fairness and discrimination in a straightforward way. And when we consider concrete cases more closely, we sort of quickly run into a variety of theoretical puzzles that we don't immediately know how to solve. Okay, so my work focuses on trying to determine which statistical criteria of fairness really do capture genuine requirements of fairness. So I think that this is, going to echo Barbara's comment that in some sense these are old problems, but they also show those problems in a new light. So I think that statistical criteria of fairness challenge pre-existing theories about fairness and discrimination, sort of by revealing these trade-offs that we didn't even realize that we were making, and that thinking through those trade-offs can teach us a great deal about the nature of fairness and how we can sort of build a more just society. Okay, so that's the sort of very big picture. I'm going to flesh that out a bit by talking about a concrete example that I'm sure many of you are familiar with. So COMPAS is a recidivism prediction algorithm that estimates the risk that a defendant will commit a crime within 2 years. It's used to make various decisions in the criminal justice system, such as decisions about pretrial detention and parole. And in 2016, ProPublica argued that COMPAS is unfairly biased against black defendants. So their argument relied on a statistical analysis that found that COMPAS tends to make different kinds of mistakes for black and white defendants. So specifically, they found that COMPAS violates a statistical criterion of fairness called equalized odds, which requires that the false positive and false negative rates for a predictive model be similar across groups. So you can see in the table here, COMPAS appears to have a higher false positive rate for black defendants. So in the ProPublica's data set, which is from Broward County, black defendants that were labeled high risk by the algorithm were almost twice as likely to not go on to reoffend as white defendants that were labeled high risk, so the false positive rate was higher for black defendants. But on the other hand, white defendants that were labeled low risk by the algorithm were significantly more likely to reoffend than black defendants that were labeled low risk, so the false negative rate was higher for white defendants. And that seems to suggest, and ProPublica argue that it does suggest, that when COMPAS makes the wrong prediction about whether someone will commit a future crime, those errors tend to be sort of beneficial for white defendants and harmful for black defendants, which seems unfair to black defendants. Okay, and that reasoning seems to suggest that this sort of statistical criterion of fairness, equalized odds, really is a sort of important requirement of treating people fairly. Okay, so I don't have time to go into the details here, so I'll just briefly mention some of the problems that I think about. So these are all sort of philosophical problems that we'll need to resolve in order to determine whether equalized odds really is measuring something about whether people are being treated fairly. Okay, so here's some of those problems. So first, various other researchers, including the researchers that initially developed COMPAS, argued that equalized odds isn't a requirement of fairness because it's incompatible under normal conditions with another statistical criterion of fairness, which is called equal calibration. So equal calibration, what it requires is that defendants that receive the same risk score go on to commit new crimes at similar rates, regardless of their race or their social group membership more generally. Concretely, if white defendants who receive a risk score of 7 from COMPAS, it's sort of 1 to 10 scale, reoffend about 70% of the time, then fairness requires that black defendants that receive a risk score of 7 also reoffend about 70% of the time. So it's tempting to think that if an algorithm satisfies this criterion of equal calibration, that means that its scores mean the same thing for defendants regardless of their social group membership, which seems to show that the algorithm isn't biased on the basis of race. It's sort of tracking recidivism the same way regardless of the race of the defendant. And so if you think that's a real genuine requirement, if you think that's right, then that might suggest that equalized odds isn't a requirement of fairness because you can violate it while satisfying equalized odds. Okay, that's the first problem. A closely related problem is that equalized odds doesn't consider what evidence is available to the decision maker. So in some cases, a predictive algorithm can violate equalized odds because the available evidence makes it harder to make accurate predictions for one group than another. It's just harder to differentiate which members of the group are high risk versus low risk for one group as opposed to another group. So in these cases, you might think that we shouldn't blame the algorithm. Instead, we should sort of blame the evidence that's available to the decision maker. It's not the decision maker's fault that it's harder to draw these distinctions for a particular group. So, and statisticians call this the problem of inframarginality. It's been discussed for a couple of decades. Okay, that's the second problem. Third problem, equalized odds doesn't include a causal condition. In particular, it doesn't require that error rate disparities be sort of causally explained by group membership. But you might think that disparities in error rates are only unfair if they're causally explained by group membership in the right sort of way. That's a sort of common thought in the literature on discrimination. Okay, and so finally, equalized odds doesn't take downstream consequences into account. So as I mentioned earlier, downstream consequences often matter a great deal, even if we're just focused on equity. Okay, so these all look like quite serious problems, and they look like they call this intuitive argument that compass is biased into question. So I think they can all be answered, and some of my work tries to answer some of these objections. But I do think that answering them is going to require us to get clearer on why disparities in error rates matter and how they're related to our pre-existing tools for thinking about fairness and discrimination. And it's also going to require getting clear on what it means to say that something is a requirement of fairness when we're talking about predictive algorithms. So, since we have only have a few minutes here, I don't have time to go into how I propose to answer these objections, although you're welcome to ask me about it. But I hope this gives you a sense of the kinds of problems that philosophers that are thinking about algorithmic fairness work on, and why those problems matter, as well as why solving those kinds of problems is going to require drawing on expertise from a wide variety of disciplinary backgrounds. All right, and now up next we have Hina Shaikh.
Perfect.
Let me get your presentation. All right.
Perfect. Hi, everyone. We're in that in-between moment, so I think it's both good morning and good afternoon. Wow, that joke really hit. That's shocking. I was debating it, but I'm glad I said it. So hi, everyone. Fantastic remarks before me that are just so important about privacy, about error rates. And I think it really helps us get to the point that I'm going to talk about, which is community-based algorithmic justice. So that's a big title. It's a big title, and it's a big idea. So I want to start out with an African-American studies scholar and also a critical feminist data studies scholar, Ruha Benjamin, who has a quote that has been quite important to the development of multiple fields. And that quote is, "Remember to imagine and craft the worlds you cannot live without, just as you dismantle the worlds you cannot live within." So Ruha Benjamin's work has been particularly important in inspiring some feminist scholars to develop something called the Feminist Data Manifesto. So I'm going to read I'll read two. And I'll have you read one. So we refuse the use of data about people in perpetuity. We commit to embracing agency and working with intentionality, preparing bodies or corpuses of data to be laid to rest when they are not being used in service to the people about whom they were created. When I bring this up in my classes, it's quite an intense statement to say that you will not use a data set forever. What does it mean to put data to rest? And I think, again, we're going back to this question of consent in such an important way for us to think about what it means to think of consent as an ongoing process. What does that mean? Number 8, we refuse work about minoritized people. We commit to mobilizing data so that we are working with and for minoritized people in ways that are consensual, reciprocal, and that understand data as always co-constituted. This is something that has been extremely important in the development of my data justice lab here at UF. And it has been incredibly important to continuously negotiate with the students in my lab, our community partners, and consistently create intentional, thoughtful, careful, and as you'll see, very slow ways of doing work. Very slow ways of doing work. But how do we do this work? How do we refuse work about minoritized people and instead work with them? How do we create ways of having shared language about practices that may seem too technical to explain, hard to understand. Even that in and of itself has been quite a task for the computer science and data science students who work with me. How to communicate, how to have shared language. So my lab was invited very recently, well, I guess last year, was invited last year to a series of community meetings in Gainesville. We were invited to attend because we were asking community organizations in Gainesville, how do we create data and analyze data in ways that is helpful to you? How do we have collaborative practices of developing AI models together? And the first real extensive response we received was to attend a series of meetings in Gainesville, the city council, and most recently in other public forums as well. And it was specifically about a case with Terrell Bradley in a K-9 unit, one of Gainesville Police Department's K-9 units, who after that horrific interaction left Bradley with stitches, left Bradley without the use of one of his eyes, fractures, spinal leakage. I mean, the list of things that Bradley continues to have to deal with are horrific, absolutely horrific. So we started to communicate with community partners, like what is meaningful to you in this moment? What would help? And the obvious first response we received is get data. Get data, request data, help us get data, help us analyze data. Talking through what it means to have structured versus unstructured data. What are the different ways that we can create structured data collaboratively together? Kind of going through the basics of what it means to have these types of skills. So we were asked to see if we could retrieve data on K-9 unit history within Gainesville, data on K-9 unit history within similarly sized police departments in cities and counties in Florida, demographics of officers and arrestees in K-9 unit interactions. And we quickly learned in my lab that every single police department, pretty much every police department in the state of Florida has entirely different language for how they label their data sets. So we ran into the problem of having to, we now know records people at all of these police departments so well that we receive holiday messages from them, which is exciting, but we know them so well because we've had to consistently ask them, what are the historical ways that you labeled this data? What are the ways that you label demographic data? And all of them have different reports, all of them have different databases, data sets, different ways of giving us the information. I had to run around the other day with a CD and try to figure out which UF computer on campus has a CD drive that I can use to access 4 files. 4 files, goodness. So we've learned a lot. But after attending this community meeting, we also had a couple different pathways of how to think with community members, of how to think about ways that we could contribute in that particular moment. And a part of it was to think historically. Think about archives, the Gainesville Sun archives, or I guess the Gainesville Daily Sun too, depending on which era you're thinking of. And then again, thinking about data as a historical process, a community-based process. One of the main arguments that GPT made was that K-9 units have historically been used to save women and find missing children. So we said, we're gonna fact check this. We are still fact checking it. It is taking so long, but we are dedicated. I'm hoping that we do it before the next student graduates, which is just coming up soon. So again, we have multiple projects happening. We have data collection efforts. And one of the questions that we constantly had to consider amongst one another is, should we make this data public? Well, for some of our community partners, it was obvious, yes, make everything public, but then some of the data we were receiving was containing so much personal information about people who've been arrested. So again, we had to think about consent. Like, what does it mean to consent to have your data displayed in this way when you were, in some cases, not even convicted of anything? You're still technically innocent. So what does it mean for us to share data even in that particular way? So all of these are continued conversations that we're having in this slow work of community-based justice. So yes, we shifted our research question, which now we have 4 or 5 research questions going on at the same time. And one of the main arguments that we have that we've collectively come up with as we've looked at the archives of the Gainesville Sun or Gainesville Daily Sun, and we not only looked at their data, well, we converted it into data in very different ways. We also looked at historical policing data too. And one of the arguments that we're making in an article we're collectively working on, which is itself a very interesting process to collectively work on an article, is that the historical and present-day usage of women and children relies upon defining perfect victims and disposable victims, namely Black men. We're still waiting on the data to answer how many women and children saved over time through using K-9 units. I now have so much knowledge about the history of K-9 units in the United States. I could win a really specific game of Jeopardy at this point. What have K-9 units in Gainesville been used for, which has been a really interesting question. But in the end, what I want to end with is just trying to think with you all about how important it is to have multiple stakeholders at the table when we define our data and AI questions. When we define our research questions, how do we center the communities and the people who will be impacted the most by the answers that we're receiving? So thank you.
Okay, so now we're going to do audience Q&A. So I guess we'll just... And I have some questions for them.
Do you want me to?
Sure, yeah, if anyone...
Do we have questions?
I have a list if we don't.
You want to kick us off and then I'll...
All right, I'll kick us off. So, Hina and Barbara, you both spoke about consent, but your emphasis was very different. So Barbara suggested that there were many cases in which requiring consent would be a mistake because it would sort of both entrench bias and sort of make us miss out on the very social benefits that we would garner if we didn't require consent. But then Hina suggested that so consent was sort of an essential requirement of justice in working with data, which suggests that you might disagree about how we should weigh the sort of competing interests that are involved. I don't know, I might be reading too much into your talk. But sort of the idea was just I wanted to invite you to engage with each other's remarks to sort of maybe help us localize if there are any sort of differences in how you're thinking about this issue.
Let me see if I can get this microphone to consent to work. Does it work? Good, okay. Consent is, of course, very important, and I don't wish to say I'm against consent. What I am very much against is the fact that when working with populations who are going to be studied in research, there's a tendency that experts such as bioethicists and scholars and institutional review boards decide what will be the terms of the data use. You know, they set the rules of what can be done with the data. Researchers decide what are we going to do with the data. And there's no voice of the data subjects in those decisions. We reduce the decision they have to consent to one thing. Okay, here's what we're doing with your data. Here's the privacy protections we will or won't provide. Now, are you in or are you out? So all you can do is refuse. And one thing I would like to see is to involve the people whose data we're studying at an earlier phase. And it sounded like this is exactly what you're doing, to decide what would you like to see studied using your data? What sorts of questions do you think would benefit you if we took your data and studied it? Have a voice at that phase. And then also, what privacy protections do you want? Do you want any use of your data to be subject to a data use agreement that says it cannot be de-identified, and that agreement will be enforceable, that if they re-identify it, you can sue them? Or, what rules do people want? We're not engaging people in that early phase of designing the data use and deciding the term. And maybe getting consent wouldn't be so hard if we could invite people earlier on to have a say in how their data will be handled and for what. So.
Yes, wow, that was excellent. Thank you so much. And thank you for the question. Thank you for the question. I also think it is just so important to think about what it means if someone revokes consent and how that can matter. And that is something that I've been thinking about with a lot of my community partners, is that they use UF Health Services. And if they use gender-affirming care services, and that's a broadly defined idea and concept and practice, then did they consent to the way that it was given over to the state of Florida? And what does it mean that their consent is ongoing and considered automatic? What does it mean? So thank you so much.
We have a question over here. Oh.
Hello, my name is Yiwen Yu. I'm an assistant professor from Agriculture and Biological Engineering Department. Thank you for your presentations and for all the presenters. Actually, I have a question for all of you, potentially. So the data in agriculture that we are working on is quite different from the data that you guys mentioned here, that is for people, for this privacy. So we are working on environmental information. So the privacy is not a big concern in our case. But I think it's very inspiring and insightful when I saw Dr. Evans' slides about these duty-based data ethics. So we're thinking that how data can be considered as a property that is owned by a person, and in healthcare or in other community-based data analysis, it's not the product is directly used by people. It's normally used by hospitals, research institutes, or government. But in agriculture, all these AI products is used by farmers. And data is actually directly get from farmers to produce these models. So basically, the ethics situation in agriculture is, farmers provide the data. And then companies produce these AI modules and resell back to farmers. So those are the big ethic issue in agriculture is companies are getting richer and richer because they charge farmers more and more. But farmers are contributing for this development and basically get less and less if the price is high, right? So we are trying to figure out how these ownership can be, really assigned to farmers. And basically, there's no personal privacy a lot in this data. It's all environmental facts. So how one thing is legally, all these data ownership regarding data products. And also, I like Dr. Grant's comments about these downstream consequence. So basically, how the data has been shared with the companies and produced the data models and resell back to farmers as a consequence from downstream. And also from community-based ethics, how farmers can be engaged or into the development on this and give comments about how the sales practices should be and how these contributions can be monetized or credited in this case. So, yeah, thank you.
I'll be happy to start. People have strong feelings of ownership over data they originated. And ownership is a good metaphor for how we feel about data, whether it's data from my farm that I provided or my health record. But the legal reality is that data ownership is not really protected by law. And that's true everywhere. Both Europe and the United States have a civil rights approach to data. The originator of data has certain rights of access to it, rights perhaps of deletion, rights to but not ownership. And people who advocate for data ownership often have an unrealistic understanding of what ownership means. Suppose you own your house and you own it free and clear of a mortgage. That doesn't mean that the state can't take away your house to build a sports stadium, eminent domain. And it doesn't mean that public health authorities can't decide to demolish your house if it's rat infested and posing a hazard. Ownership is always contingent on duties to society. I'm perhaps going on long, but to get to your question, what is proper compensation when a farmer has provided data to a commercial entity that is developing a model that may be useful and then wanting to sell it back? Should there be a discount? The problem is the contributors of data. One person's data usually aren't very useful. It's from getting large samples of data that make a valuable product. So any individual's contribution may be 5 cents to the total value of the product. So its monetary compensation doesn't necessarily address the issue. I think things such as making sure that those uses of data do provide a public benefit. For example, don't take my health data and invent a drug and then sell that drug for $120,000 a pill so that I can't afford it. I think it would be justified to have codes of conduct for people that want to use data, that they will not engage in excessive pricing, not misuse it, and have some public benefit requirements. But letting people own their data, it won't be worth as much money as they hope it is. And I'll add, in healthcare settings, if a HIPAA-covered entity gives data to a software developer and then in return gets free software back from that developer, that's an unlawful sale of data for remuneration and can lead to all sorts of legal problems. So you really have to be careful how you structure transactions with data.
We have another question if you want.
That'll settle the dispute.
Hi. The question is for the whole panel, of course. Where do you think the balance is, or if there even a balance could be achieved between someone who is part of a minority or a marginalized group and sharing their data so that they're accurately represented in the data set with the fear of that same data set being used against them?
Thank you so much for that question. That was such an excellent phrasing of the question and the stakes at hand. I think a way to answer this is to think about the fact that I believe the statistic is over 2/3 of Black men are in some criminal database. So we can begin to think about what it means then to develop products for any type of system that uses that type of data automatically. And you can see that in Gainesville's own police department, how they have collected their data and what their data tells them to do in terms of policing, consistently will tell them to go to the east side of town. So again and again, like, we have to wonder who has been marked over and over again, whether archivally or in data, and how do we develop new ways of not just marking people so that we add data and create more, I guess, forms of equity, although I really appreciate the way David's making me rethink my language. But I think we have to really think clearly about historical consequences of developing products without thinking first of what the data availability is. So thank you. Thank you for that. Dave, would you like to? There you go.
Well, I can say that it is now 11:50, so I would like to thank Barbara and Hina, as well as all of you, for being here today.